Hello, Colorado Realtors. I'm Scott Peterson. Thank you for joining me for another edition of Legal Bites. I'm telling you, I'm going to start firing these at you guys more quickly. We got this new beautiful studio, and life is good. So I'm going to keep doing these. No more complaints about these long droughts between your Legal Bite fixes. I know many of you need these to. It's like food and sustenance for you. Hopefully not. Anyhow, today we're going to step out of our commission position statement series for an episode here, because I'm getting a lot of questions on this particular issue. And I've had some people request a little bit of clarity on this. And it has to do with Colorado security deposit limitations. Now, I know many of you have nothing to do with property management, don't own or invest, you don't have tenants in your world, but I'm going to talk about both sides, because this does apply to something that you guys use from a brokerage or sales standpoint in your brokerage businesses. So based on what was called Senate Bill 23-184, this is your state legislature passed this bill last year, signed by the governor last May, went into effect, I think it went into effect January 1st. It may have been a little bit earlier. Point is, it's now in effect, is security deposits that a landlord charges a tenant in the state of Colorado, no matter what the situation is, they are capped at 200% or 2 times the monthly rent. In other words, you can't have a security deposit for whatever reason. Maybe you're renting to a bunch of college students or whatever that are maybe going to be a little harder on the place. I hate to not discriminate against college students, but you know how they are. I was one once myself. And you want to have 3 or 4 times the monthly rent to make sure that you've got enough damage deposit at the end. That does not work as it relates now to this new law in Colorado. It's 200% or 2 times 1 month of rent is the limitation on security deposits between a landlord and a tenant. So be aware of that. If you are currently a landlord and you have tenants, there is now this cap. And so make sure, obviously if you're a property manager, you've got to be aware of that. That's your job, to be up to date on this stuff. But if you're an investor owner, you might not pay as much attention as a professional property manager would be to that issue. So this is current state law, 200%. Pretty common in terms of that amount. It's not uncommon that you would have security deposit to be 1 or 2 times rent. But in the event that you've got something different, be aware that that is inconsistent now with Colorado state law. The other thing, though, that I've been getting issues on and more questions about is post-closing occupancy agreements. So you do a transaction and the buyer is kind enough to give the seller 45 days of post-closing occupancy through a post-closing occupancy agreement. Well, remember, a post-closing occupancy agreement is effectively a lease. It is a lease by a different name, so to speak. In that case, the buyer is the landlord, and the seller, who's still in possession of the property, is going to be the tenant. That is not an exception to this state law, and it is not uncommon in a post-closing occupancy agreement, for a buyer to not charge rent. Well, if you're a buyer and a landlord is a buyer in a post-closing occupancy situation, and you're not charging, you're charging 0 rent, 2 times 0 is, I think, based on my last math test, is still 0, and so you can't charge a security deposit in Colorado. And so, how that interplays in your post-closing occupancy agreements, just make sure that, again, if you're representing sellers, they're aware of the fact that, if they're not paying rent, then they can't be charged a security deposit. And similarly, if you're working with a buyer and they're going to offer free rent or no rent during the post-closing period, they aren't allowed to charge a security deposit to the seller/tenant. So it's important to be aware of that. PCOs are not exempted from Senate Bill 23-184, which again is now the law in Colorado. Hope that clears some things up. If you have questions about this or anything else, we'd love to hear from you on the Car Legal Hotline. It's available from 9 to 12 and 1 to 4, Monday through Friday, and we'll see you there and on the next edition of Legal Bites. Thanks, guys.